It is very, very difficult sometimes to ascertain the whereabouts of a will post the death of a loved one. The way that you usually approach that is, the first step is of course to search the house where the deceased lived. But before you do that, you must seek the approval of any relative, otherwise you could get into some difficulty. The other option is sometimes to ask the local probate registry, and there are probate registries that are located around the country where, provided you have the details of the deceased, you can actually secure the whereabouts of that will if it's already been lodged at court. Because there is a facility that's available at the probate registry to lodge an original will even during the deceased's lifetime by paying a one-off fee of £20 for storage. And one of the other ways that you can ascertain the whereabouts of the will is to apply for what's called a standing search. A standing search is a process whereby an application is made to the probate registry to find out whether or not there's been other will or any other will that's been lodged relating to the deceased. Of course, there are also solicitors sometimes that retain a will, and it may be that the deceased may have had an association with a firm, a local firm, that he may have used throughout his lifetime, and sometimes it's worth approaching that firm to see whether or not they retain a will in storage. Now, of course, they may or may not provide you with that information because they have an obligation of confidentiality, but of course, if it transpires that the will has already been proved at probate, that is the mechanism that's used to prove a will, then that document becomes public record, and you can go online and search at the Probate Service website under the Gov UK website, whereby you pay a fee of £10 and you can secure a copy of the grant as well as a copy of the will. And last but not least, of course, you can approach the bank, because if the individual retained the will at the bank, that is the deceased, then you can make an inquiry there. The bank may refuse to give you access to it on the basis that they will require some sort of evidence to suggest that you will be a beneficiary or an executor under the terms of the will. So it's always good practice probably not to leave it with the bank, or leave it with the probate registry, which you can do throughout the lifetime, or with a solicitor. These are sometimes the practical problems that arise, and it's always worth having an idea or a concept of how to find out about a will, because sometimes it's a difficult situation because people are distressed and they're anxious. They want to find out what they need to do, and they need to do it quickly post the death of a loved one.